CBS Radio News, pulsing the earth with amplitude modulation on 1240. NASCAR, Bloomberg Markets, David Tulis, streaming strong at Noogaradio.com. Live on YouTube and Facebook. Nooga Radio, News Talk 92.7. Chattanooga Radio.
Good morning. This is Trevor Atchley. I'm here for our weekly radio show, Legal Bytes, where we discuss a topic or two for legal discussion. And I'm joined this morning by Attorney McLean Stoller. McLean, thank you for joining me.
Thank you for having me. Good morning.
Good morning. And we, as many of our listeners know, each week we pick one or two topics to discuss. And we're certainly interested, if you have any questions, for you to give us a call. Our telephone number here is 423-800-8949. And in the past, we've discussed a number of issues. We've covered a couple of times probate administration and wills and estates. And one issue that sometimes occurs in the context of inheritance or successors in interest to title to real property is a situation where two or more individuals hold legal title as tenants in common, and situations can arise where those tenants in common do not want to own that property together. McLean, have you ever in your practice seen a situation where that's occurred?
Yeah, I have encountered that. We are actually dealing with the case right now with that.
And how does it, in your particular case, how did the individuals acquire title to that piece of property?
There were three siblings, and shortly before their father passed away, he transferred title to all three siblings to share an undivided interest in 9 acres of property.
And so that's the general characteristic of holding title to real property as a tenant in common, is that each tenant in common holds an undivided interest in the real estate. And each tenant in common is allowed to have access to the property and its use and enjoyment of the property. So that there certainly can arise situations where conflict can develop.
There is.
And we've discussed this some before, but it's not all that uncommon, too, for there to be some simmering family conflict which exists that can exacerbate disagreements which might otherwise arise, where each person who owns an interest in the property has an undivided interest to the whole.
Correct.
And those family conflicts certainly can exacerbate those problems.
Yeah, and in this situation, basically, we've got one sibling that wanted to sell the property. We've got another sibling that wanted to keep the property, and there's one that really doesn't care one way or the other. But the one that wanted to keep the property also would not buy out the one who wanted to sell's interest. So that's where we get the problem.
Okay. And so if a client comes to you and says, presents to you this general fact pattern, what's their remedy? What do you do?
We would file an action for partition.
And in your particular case, I think you mentioned this was a 9-acre parcel. Is that correct?
Yes.
So it's suitable for partition. What if it was just a house and lot and you can't divide it? What would be the remedy there?
Sell it.
Right. Okay. So you can either file a lawsuit for partition, and partition, I guess, means you divide the property and each owner gets a portion.
And from what I understand, that is the preferred remedy. They want to try and divide the property, if possible.
When you say they, you mean the court?
The court.
And if it's not, if partition is not, so then you have to show that partition is not possible, and then an alternative, ask the court to sell it.
Yes.
And in the case you've been talking about, it's a 9-acre parcel, and they think it's suitable for partition.
Yes, they came up with a couple of different options, and presented it to the siblings. And I think right now that they've agreed on one.
Okay. And when you file an action, where would you file it?
We filed it in Chancery Court in Hamilton County.
And I suppose you would file the lawsuit in the county where the land lies.
Exactly.
And in this particular case, we were talking on the way over. It sounds like they've actually appointed commissioners to go out and to look at the property. Explain to us how that process works.
By statute, the court appoints commissioners. They are sworn in, and they are to give an oath. And the commissioners, basically, they conduct surveys. They are given instructions on how they think is best to divide the property. And they present it to the court.
Okay, so in this case, 3 people own the property at tenants in common. It's a 9-acre tract. Commissioners have been appointed. They're supposed to go out and then, I guess, do surveys wherever they think is necessary to advise the court on how to divide this particular parcel into 3 shares.
Yes.
So if there were 5 owners, 5 tenants in common, then I guess you'd be looking at a situation where you would have to divide it into 5 shares.
Correct.
And the commissioners, how are they determined?
My understanding is that they're appointed by the court.
And are they just regular people like with no experience in real estate, or are they people that have a certain knowledge of real estate?
In our case, we have a man that actually conducts surveys, and we also have an appraiser. Now, we have not had the third one appointed yet, so I don't know who the third one will be.
Okay. And I guess to go back to our original premise, the only reason this would be necessary is if the people who own the property, the tenants in common, can't agree on what to do with it.
Correct. And that is absolutely the case in this situation. They are disagreeing on what to do with it.
So you have a situation where 2 or more people own title to real property as tenants in common, and they can't agree how to divide it between themselves or whether to sell it and divide the proceeds. So then you have to file an action to ask the court essentially to give you a remedy.
Right. And originally, the sibling that wanted to sell, like I said, the preferred remedy for the court is to divide it if possible. And the court determined that it was going to be easily divided. And so they have not agreed to let it sell yet. If that's an option in the future, we may try and revisit that. But as of right now, the court said, no, we can easily divide this property. We're not going to allow you to sell it.
So that when you say divide it, that's the actual partition.
Correct.
And I guess once the property is partitioned, then each person would own just a certain portion of the property.
And then they can do whatever they want with it.
Because they would own title solely in their name at that point.
Exactly.
Okay. And the commissioners, so they're appointed by the court, they're sworn in, they take an oath. How is that process going to work?
My understanding is that they go and conduct the survey. They present their findings to the court, and they advise the court on what they would suggest that the parties do and how it should be divided.
So I guess then the court ultimately makes a decision on how to divide or partition the property based upon the recommendations of the commissioners.
Based upon the recommendation of the commissioners.
And all of this sounds like it could be incurring quite a significant amount of cost.
It could.
And with all the costs associated with all this, how is that paid? Would it be paid by the individual parties to the action, or does the court have discretion on how to assess the costs?
It would be paid by the individual parties.
Now, if you were selling the property, I suppose the proceeds could be paid from the sale, but here we're dividing it in kind, a partition.
Right.
So the parties then would have to pay the costs as they go, I suppose.
Right.
And so you're talking about in this case a situation where the successor in interest was the party's father, and he actually gifted this property to his children before he passed away.
He did, and the children, they've had a tumultuous relationship, and they just can't agree on what to do with it. And it's actually gotten to the point where they did originally have a survey conducted, and they divided the property, and that's where they got the diagrams that they chose from on how to divide the property. One sibling did not agree with the survey, so we actually just went to court recently and asked that a new survey be conducted with that sibling's choosing of who the surveyor is, so that once we get down to it with the commissioners, there's no argument because she got to choose her surveyor as well.
I see. And I see this in my practice frequently in the context of either an inheritance as an heir at law or as a devisee under a will, where two or more people inherit title to property and then can't agree on whether to sell it or whether to divide it amongst themselves, and you end up having additional litigation. One thing I want to talk to you about is ways any of our listeners could plan to avoid this type of situation.
I'm sure you've encountered this much more than I have with your estate work.
Well, I have encountered estate planning, and I guess the primary two avenues for addressing the issue would have been, in this case, for example, for the father to sell the property to a third party while he was living.
Right.
And that may not be what he wants. He may want the property to go to his children. So the ways to deal with that is, in the will, you could direct that the real estate is to be administered as a probate asset, and then give an independent executor authority to decide how to partition the property and then to devise it to the three children in equal shares. And then the executor has authority to do all this, someone who's independent of the parties. So then you wouldn't have this conflict among the children, although there would probably still be some room for dispute if they didn't agree that what the executor decided was a partition were three parcels of relatively equal value. I don't know that there's any way you can get around that particular situation where the people receiving the property may disagree as to whether or not the parcels partitioned out from the whole are of relatively equal value.
Right. And one of the big problems with this particular case is that each of the siblings own a lot that's connected to the parcel that they share. So they're trying to divide it in a way to where their portion that they get is connected to their lot.
That makes sense.
And why they can't agree on this, I do not know. It's sibling antics, and so it's not just a piece of property out in the middle of nowhere that you can just divide easily. That's what makes it a problem, is that they've all three got separate parcels that are separately solely owned by them, that are connected and surrounding this one big piece of property that they were all gifted.
I see. And do they each use this main parcel for ingress and egress to their respective lots that are connected?
One of the siblings actually has to go over one of the other siblings' lots, and so that has actually come up now as a problem. So we've got to actually work around that as well on how we divide the property, so that they can get to their separate parcels easily.
Right. And this happens, just so our listeners know, these types of problems of ingress and egress to a parcel of property and whether one has to traverse over an adjoining owner's property. The remedy there is what we call an easement.
Right.
But generally, easements are something two parties agree to. There are implied easements, an easement by necessity or one acquired through prescription, which is similar to adverse possession. But all of those are not an agreement per se between the parties. So you run into another area ripe for litigation.
Right.
And so one way to avoid this problem potentially would be to leave a last will and testament and provide in your will that real estate to be administered as a probate asset, and then give the executor authority, independent executor authority, to divide this particular parcel and devise it to the children. The other remedy probably would be using what is called a living trust or some type of trust instrument, where you convey the property to an independent trustee with instructions upon the death of the settlor to divide the property, partition it in equal shares, and then convey one share to each child. And the reason why both of these, whether it's through the will with the independent executor or through a trust with independent trustee, the reason why these often are more successful than leaving property equally to the three children and letting them decide is the independent fiduciary is not going to have, well, he's going to be unbiased, and he's going to be able to make decisions without the simmering tension that's been existing between the three children. Would you agree with that?
I agree with that. And honestly, the testator, if he left it in the will, he could also leave out instructions on how it should be divided.
That's absolutely
and
correct.
He governs it.
That's correct.
Because they've these siblings, they also have, they're alleging different conversations occurred when their dad was alive on how the property should be divided.
So if he had put something in writing, specifically and expressly stating his instructions, the children might not necessarily have agreed with it, but that could have alleviated a lot of these problems.
Yes, and a lot of litigation cost.
And so this is a situation where the parties now are incurring great expense, some of which probably could have been avoided if the person who owned the property originally had put his instructions in writing.
Correct.
That's very interesting. We have, last time I was here with Attorney Jim McCoon, we were talking about things to avoid as far as pitfalls we see in our practices. And one of the things we were discussing was inheritance and how property is going to pass to our heirs at law or beneficiaries under our will. And this is a great example of the type of situation you can avoid by putting your wishes in writing in an enforceable last will and testament or trust.
And do you instruct your clients to do that?
Well, we certainly do. Sometimes clients, when they're making a will, you have to have a candid conversation, because sometimes the testator is the person that makes the will. They don't want to discuss some of the underlying family tension. But for this type of reason is exactly the reason why it's necessary for the testator to discuss that with his or her attorney. And of course, those discussions are confidential and privileged and can't be disclosed to third parties even after the testator has passed without a waiver executed by the executor. So it is something that the client needs to bear in mind and have a very candid conversation with his attorney or her attorney, so that these situations can be addressed on the front end. And I think from your experience, you would agree that's probably a much more cost-effective way of trying to address these things.
Oh, it absolutely is. I know of one person that has several children, and she actually made a decision that she's going to list out. She's got a lot of jewelry, and to avoid any conflict, she's literally going to list out which child gets which jewelry. She's also going to leave instructions with respect to some trusts that she set up. She's going to be very specific and said that not to say that she doesn't think her children would go to litigation, but this is a precautionary measure that she's taking. And I think it's gonna really help in the long run.
Well, I agree. It doesn't necessarily mean there won't be any problems during the administration of the estate or the trust, but it certainly provides clear instructions on how the settlor or testator intended for that person's property to pass.
Exactly.
And that can alleviate a lot of family conflict. If any of our listeners have any questions about any of these matters, please give us a call. Our number here is 423-800-8949. Again, this is Trevor Ashley. I'm here speaking with attorney. I just got your name.
Wow, thank you.
McLean Stoller. I was so focused on getting the number correct that I slipped my brain there for a minute. But we're here today. We initially were talking about partition actions, and that has led us now to a discussion about what we would call inter vivos planning, that is planning during your lifetime in a estate plan or some type of trust plan to avoid some of the conflict we see where several siblings hold title to real property as tenants in common. And that's the situation we see with a fair amount of frequency, isn't it?
It is. And one of the other issues that one of our clients has brought up is with this partition action, apparently, like I said, to avoid conflict, we allowed this woman to go and get her own independent survey. And it was because apparently the original survey that was done, it did not take into account some existing structures on the property. So now you've got the added issue of these lines that they've divided the property into and saying, oh, this is the perfect way to divide it. Apparently it's going through buildings now. So that's an additional issue.
Sure.
So again, we're spending more costs doing this, but it's going to avoid more conflict in the long run.
Right.
To try and get around some of these buildings, but that's an extra hurdle that you've got to deal with when you're dividing the property if there are existing structures.
Absolutely. And I know Fielding had a case a number of years ago where it was similar. Some siblings had inherited property. They were trying to partition it, and they were just regarding the value of the parcels. There were disputes over road frontage and existing structures and access to utilities. Oh, it looks like we have a phone call. Hello, you're on the air with us here on Legal Bytes.
Yeah, I got a question. What's the advantages, if there is any, of getting married in Tennessee compared to Georgia or other states?
Well, are you talking about with respect to property issues or legitimacy of children, or is there a specific issue you're wanting to discuss, or just in general?
Well, just in general. I mean, thinking about getting married, and I just wanted to see if there was any advantages of doing it in Tennessee or Georgia or elsewhere.
That's as far as where you celebrate your marriage, there's not really an advantage one way or the other. Typically, with certain exceptions, this is a general rule, but Tennessee will recognize the validity of a marriage celebrated in a different state or even a different country. But as far as so where you get married is not the critical question. It's where you're going to be domiciled, and the state the state laws of that domicile will affect the rights of the parties as far as their relationship as being husband and wife. I'm not licensed in Georgia. McLean, are you licensed in Georgia?
I am not licensed in Georgia.
So I can only tell you, I'm only licensed in Tennessee. But Tennessee, one of the main benefits to being married is that married couples can hold title to real property as tenants by the entirety. And title held that way actually has a built-in creditor shelter protection where the creditors of one spouse cannot, they can't go after the property if the other spouse is not also a debtor of that creditor. So there's some built-in creditor shelter protection, and the creditor can't execute on the property. Now, as far as having children, there's certainly some advantage there is legitimacy of the children, where the husband is presumed father of any children born by the mother during the time of the marriage. And McLean, do you have anything to add as far as advantages?
It really comes down to, and I hate to say this, but when you get to the dissolution of the marriage, there are definitely differences, but I know he's trying to ask for the advantages of the marriage, so I won't get into that.
Well, there certainly are. There really is no mechanism for dividing property in a domestic partnership in Tennessee.
No.
Tennessee doesn't recognize domestic partnerships, doesn't recognize common law marriage. And so parties can have substantially different property rights, depending upon whether this asset was acquired during the course of a marriage, or whether it was a domestic partnership.
Right.
Caller, has this answered your question? Do you have any further?
The Tennessee Valley's news, talk,
appreciate
and
it very much.
Well, you're very welcome. And we got cut to break there, but if you have any more questions, please give us a call back.
All right, thanks.
Thank you.
Safety director and the director of the EMA have both been notified. There was a minor shelter-in-place call for a short period of time. It's since been lifted. It only lasted for about 30 minutes. A 5-year capital budget was approved by the city council that allows for almost $20 million for the Central Avenue extension. This would go between Erlanger and Amnicola Highway. Opponents, however, say that the construction would disturb a historic black area, Lincoln Park, and a Native American burial mound. The city says it will do its best to avoid those critical and historic areas. Russell Stroud, Nooga Radio News Talk 92. 92.7 now.
In-depth traffic, news, and information. Mornings on Nooga Radio, AM 1240 and 92.7 FM.
Nooga Radio News Talk 92.7's fast forecast now. 61 degrees for our mid-afternoon. Wind and rain coming in from Hurricane Irma, which has now been downgraded to a tropical storm. 63 for a high today and 61 for the low. Tomorrow, we're expecting yet more rain and high winds, with temperatures getting up to 65 for the high and 60 for the low. Rain is expected to continue out till Thursday. That's your fast forecast now.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
You've been in a wreck.
756-6400.
You've been wrongfully fired.
756-6400.
A turkey is suing you out of the blue.
756-6400.
Confused about a business startup?
756-6400.
That's the number for you. 756-6400. Right here, right now, Chattanooga. Call now. Top flight legal help awaits. Get biz advice now. Representation to fight for your right. What are you waiting for? That's 756-6400. Don't sit on your rights. You've got remedies. Turn your tragedy into cash. You've got the solution from estate planning all the way to probate. Act now. Top attorneys in Chattanooga are waiting to help you get relief. Act now. No out of pocket. You don't pay a dime until we win. So win with us.
756-6400.
Call now. Top flight legal help awaits. What are you waiting for? That's 756-6400. Turn your tragedy into cash. Act now. No out of pocket. You don't pay a dime until we win. So win with us.
756-6400.
756-6400.
Nooga Radio, AM 1240 and 92.7 FM knows your opinion is important. So call 800-8949. Agree or disagree. Call 423-800-8949. 800-8949. Nooga Radio, AM 1240, 92.7 FM, and 95.3 HD4. News, talk, sports. Nooga Radio.
Hello, welcome back to our second half hour on Legal Bytes. And right there at the end of our first half, we had a caller asking about some of the benefits of being married. And there certainly are a number. And my co-host, McLean Stoller, mentioned that one of the primary benefits is actually not something you typically contemplate when you're first getting married, but is how you divide your property in the event of a divorce. And Tennessee, unlike some other states, does not recognize common law marriage. And currently, the state of the law does not recognize domestic partnerships. Tennessee, of course, recognizes business partnerships where two people are engaged in a business enterprise for profit, but not a domestic partnership. And so people sometimes will, in Tennessee, live together for a number of years, cohabitate, and then it's exactly this type of issue we've been talking about. Title to real property is held in the name of one individual, and their domestic partnership ends, and the other person says, what about any equity interest I might have earned in this house? And so far, at least, Tennessee courts are not recognizing domestic partnerships.
No, they do not at all.
And if they were husband and wife, I think the spouse whose name was not on the title would at least have some marital interest in the property.
Well, they can make that argument, yes, right. Especially in the equity in the home.
I guess the equity that developed during the course of the marriage.
Right.
So that's something to consider. There's also income tax consequences if you're married, and some benefits to being married. A little bit beyond the scope of what we typically discuss during our show. But if you have any further questions, feel free to give us a call back, or any other listener, 423-800-8949. We would also be happy to talk to you at our office. Our number there is 423-756-6400. And him mentioning husbands and wife reminds me of an interesting case. This is going back to some of what we discussed in the first half about partition actions, where there was a case in Tennessee a number of years ago where a husband murdered his wife. and they actually held title to real property as tenants by the entirety, which is a form of property ownership available only to husbands and wives. And the court was stuck in the position of saying, how do we deal with this? Because a tenancy by the entirety carries with it a right of survivorship, where ownership of the fee passes to the entire ownership of fee passes to the survivor. Tennessee also has what's called, was referred to in the vernacular as a slayer statute. It's a person from inheriting murders. It's having to reconcile those two concepts.
Now, is it just if they're accused of murder, or they have to be actually convicted, or?
Doesn't require a criminal conviction, but you would have to prove in a civil proceeding that the person indeed murdered.
Okay.
Obviously, a criminal conviction, an arrest judicata, or a claim preclusion would justify that finding also in a civil proceeding. But if a person was acquitted of murder, that would not necessarily preclude proceeding that indeed the person was the murderer, prohibited from inheriting under our slayer statute. And so what the court did is, under that circumstance, two concepts, the slayer statute and holding title as tenancy by the entirety, is the court held that to have a tenancy by the entirety, as I mentioned before, you have to be husband and wife, and the court found that the husband's act of murdering his wife destroyed that unity of title, the marriage, and therefore then the husband and wife would then be tenants in common. His interest, undivided interest in the property, would pass to her heirs at law because he's prohibited from inheriting under the slayer statute. Obviously, there you're looking at a situation where her heirs will be in pursuing some type of action for partition or for sale. Don't you agree?
Yes. And when you get married, does it automatically become?
No, it's typically on the deed. It will say acquired by so and so and wife so and so, and that's enough to create the tenants by the entirety. Generally speaking, though, any property acquired during the marriage, courts are going to construe that if it's titled jointly as being held as tenants by the entirety, but express that usually the conveyance will say so and so wife or husband.
Okay, and then you mentioned rights of survivorship. Do you have to specifically put that in the deed?
Not with a tenant by the entirety. No, that is a specific, I guess, nature of a tenant by the entirety is that there's a right of survivorship. Now, survivorship and other type of holding, like as a tenant in common or a joint tenancy, then you have to expressly state with right of survivorship. But it is just a natural condition of a tenancy by the entirety. And that is one big advantage of holding title in Tennessee as married couples. Again, there's a credit shelter built into tenancies by the entirety. And it, for purposes of estate planning, solves at least one problem there, unless, of course, the two couples die in some common disaster.
And that actually reminds me of a matter we dealt with. It was a couple of years ago, and there's a man and a woman. They were married for quite a while, and then they got divorced. It was probably about 7 years down the road. This man incurred tax debt in his name. According to their divorce decree, he was to sign a deed accepting title that he incurred the debt on. He never did that. And so people were going after the wife. They said, you know what, your name's on this deed, you're liable for this. And the argument was made, and there's not a court case about this yet. There was an attorney general issued an opinion saying that the divorce decree actually acted as a transfer of the property. And so it was about a $50,000 tax debt. And so she did not have to pay it. And that was good news for her because I don't know why she couldn't get him to sign the deed, but he would never sign the quitclaim deed. But that's just another issue that's come up before, where they interpreted the decree, though, as transferring the property.
The attorney general issued an opinion to that effect. That's very interesting. And this happens also in instances where during the course of a marriage, a husband and wife are jointly obligated on a debt. And in their marital dissolution agreement, they agree that for one spouse will be liable for that debt and agrees to indemnify the other spouse. But this issue's come up so frequently now, there's actually a standard provision in our documents that says this does not affect the rights of the parties vis-a-vis that creditor.
Right.
Where you both were jointly obligated on a debt. And so it's very important, obviously, in any type of where you're changing your legal status, whether it's by virtue of getting married or terminating a marriage, dissolving a marriage, to consult independent legal counsel on the consequences of that.
Right. And we typically, when it comes to decrees and to marital dissolution agreements, we typically try and put in a time period by which they have to sign all documents handling all these matters so they don't come up in the future.
That's a great idea. And then I think some also include a provision instructing the court or instructing the clerk to execute it on behalf of the spouse or the person not cooperating with the execution of those instruments.
Right.
So that you can get that accomplished even without the other person's cooperation. And so what I've found, and I think you probably would agree with this in your practice, is that situations where people have some type of relationship, whether it's a business relationship, whether it's a family relationship, whether it's a husband and wife, those are the situations where people tend to get into some of the most bitter disputes.
I would agree.
And one way of trying to on the front end address some of those issues is to have an agreement in writing, whether if it's a business, if it's an operating agreement, or bylaws to a corporation, or if it's a marriage, you might have some type of prenuptial agreement or even a postnuptial agreement that provides the rights and remedies of the parties in the event their relationship dissolves.
Right. And a lot of people are they don't want to do that because it's almost within the with the prenuptial agreement, people think that that's just dooming your marriage to fail just from the get-go. But it's actually very smart. If you don't have any assets, then it's not going to hurt you. But we always recommend that when you have your own separate assets, that you protect them.
That's absolutely true. And what we're talking about there is so you get married, and whenever the marriage is dissolved, the court will equitably divide what's called quote unquote marital property. And each party, as a general rule, gets to keep his or her own separate property. Well, just in broad strokes, separate property is any property you own prior to the marriage. And there's other exceptions for property acquired during the marriage, like an inheritance or a gift.
Right.
And just in broad strokes, marital property is any property acquired during the marriage by the parties, subject, with the exception to those things I mentioned earlier, like an inheritance or gift. And so what happens is there's situations where somebody brings separate property into the marriage, but through either transmutation or just an increase in value during the duration of the marriage, the other spouse essentially has some marital interest in that asset.
They do. If they commingle, say if I had a separate bank account and I get married and then I take that money and I put it into a joint bank account, I've commingled those funds. So they have become marital property.
And that the legal term for that is called transmutation. So it's changed, its status has changed from separate property to marital property.
Correct.
And then when it's marital property, it's subject to an equitable division by the court.
Right.
And so if you're contemplating marriage, like our caller there was, and if you have anticipating a larger inheritance, or if you currently have your own property and want to discuss ways to preserve that in the event that the marriage dissolves in the future, that'd be something you should consult with an attorney about.
Right.
And the attorneys at McCoon, Williams, Ashley, and Stanley can certainly advise you on that. Our number at the office is 423-756-6400. If any of our listeners have a question about any of these topics, please give us a call. The number here is 423-800-8949. And I think just sort of in the vernacular, people often say you should always, quote unquote, get it in writing.
Always.
And that's obviously in legal parlance, there's a different name for those different writings, but that concept is true.
It prevents a lot of problems. It really does.
And going back to our situation with the partition, if the person who owned the property originally had put out his intentions in writing, and you weren't relying on these alleged statements by the decedent, that the children are now saying this is how it should be divided, that would have gone a long way probably to resolving a lot of that conflict.
Right. Now, since you deal with estate planning, what would have happened if he had not transferred that property to the 3 children?
Well, I'm assuming the 3 children were also his heirs at law.
Yes.
So they would have inherited an undivided interest, and they'd be in the same situation.
So same situation.
Now, if he had left a last will and testament and provided in his will instructions for how that property was to be treated, then that would have gone a long way, possibly to solving the issue. Although, I mean, it's never foolproof, because somebody could still have initiated a will contest, or, could be claiming that could interpret the written instructions differently if they were in some way ambiguous. But it does go a long way if you, again, to put it in the vernacular, quote unquote, have it in writing.
Okay. Now, if he had, you had mentioned tenants by the entirety and joint tenancy. Now, if he had co-owned that property with somebody and he died, and the other man was still alive that co-owned it with him, would they still have gotten the property?
They would have.
If there was no specific language that you had mentioned about rights of survivorship.
So his undivided interest, he would have been a tenant in common with the other owner.
Correct.
So he would have owned an undivided 50% interest. And then his undivided 50% interest would have passed to his heirs. So then they each of them would have owned 1/3 of his 50%. And so you'd be looking at then a potential conflict between the 3 children as well as the other owner.
Okay.
And that's a great example of something that also happens that I see with a fair amount of frequency, is where you have multiple generations where there's been no estate planning, and title to real property is passed to successive generations under our laws of intestate succession. And it's like a spider web. It starts with one person, and then property ownership just diluted over time. And somebody comes in to see you and says, I want to try to sell my interest in this property, which you have the right to do through this action. But at that point in time, you could have up to 15 or 20 people who own an interest in the property, and you have to notice all of them and bring them all before the court in order to initiate that action. If somebody higher in the line had left any specific instructions for the use of that property and how it should pass upon that person's death, some of those issues could have been avoided.
Right. So if I inherited an undivided interest in property with 3 siblings, and then other co-tenant, they have 5 children. So it'd be all of us. If I want to sell, I've got to notice all of them. Do I have to get permission?
No. So are you saying the other co-tenant with 5 children died?
Yeah.
Okay, so that tenant common dies, right? His undivided interest then passes to his children.
So now you've got about 8 people with an undivided interest.
Correct. Now they're not equal.
Okay.
But yes, then at that point, then that one tenant who died, his children would have a 1/5 interest in whatever interest he owned.
Okay.
So it becomes more diluted. And if you wanted to initiate an action, the only reason why you not ever, but one of the main reasons you file that type of action with the court is because there's not an agreement among the owners of the property whether to divide it or to sell it. And absent that agreement, you have to ask the court to intervene and give you a remedy. And so then you would file the action in court and say, either we want to have this property partitioned, or the way this property is situated, it's not suitable for partition, so we want the property sold. And in your case, the court found that the property was suitable for partition, and that partition was necessary and appropriate. In other cases where it's just a house and a lot, and you have 5 or 6 people who have an interest, partition in those circumstances is probably not possible, and sale is the appropriate remedy.
Right. And actually, with some cases we looked at, if the property has been destroyed, or if there's a lot of trash on it, or it's basically an eyesore. There was one case where the court ordered that person, they basically got their interest. Well, they got the money from the money that they would have received from the sale. His was reduced because he had created that havoc on the property. and caused it to have to be sold, actually, because it was a mess. And so they said, we don't want this property. We wouldn't even know what to do with it. It's too much money. And so the court did approve sale on that one. And then they reduced the tenant who caused all the trash. They reduced the amount of money they got from the sale.
By the value, however much he had, either the cost to remediate or however diminution in value could cost to the property.
Correct, because I think in that case, it's been a while since I read it, but I think the court gave him an option: either clean it up or the amount you receive is going to be reduced.
That makes sense.
And
seems like a fair remedy if he was the one that caused those problems.
Right, and he didn't argue; he just took a reduced value.
That is, those types of issues unfortunately arise with a fair amount of frequency. And it often is very, very close relatives, siblings, or, cousins who have inherited property. And
you think family would get along more so than strangers, but actually it tends to be the opposite sometimes.
It does. And it's particularly true with interest in real property. And the law respects this, that real property is unique and therefore it's treated specially. So that's probably part of the reason for the public policy that if partition is possible, the court is to partition the property as opposed to selling it, because the court wants to preserve, to the extent possible, that owner's interest in this unique property. And I've also seen it in boundary line disputes. Do you have any experience with boundary line disputes?
I actually do not have any experience with that.
So this arises in a context where, obviously, as it implies, you have adjoining property owners, and there's a dispute over the common boundary. And what we're finding is, or what I found in my practice is, that a lot of the property descriptions, particularly from a long time ago, were created by surveyors with equipment that at the time was what they used, but with what modern equipment now is much more precise. And so what's happening is that we're finding boundary lines are not accurate. And sometimes, based upon these old surveys, there's not actually, an old survey may say that there's 100 feet of road frontage from point A to point B, but modern surveying equipment may show that's incorrect. It's either longer or shorter than that. And so the boundaries of the respective properties now are having to be adjusted, and adjoining property owners get into disputes over how that boundary line should be established. Sometimes someone's installed a fence, and there's a question of whether the boundary line's been changed through some sort of prescriptive use, where they've essentially held adversely to another owner. But those issues can be some of the most divisive and difficult to resolve.
Do you encounter a lot of those?
Well, I've had a couple of boundary line disputes, and they're all just, and I understand, because if that property is your property, it's unique and it's yours, and you think you've owned a certain parcel that's, by these bounds, whether it's by meets and bounds or whether it's landmarks, how they describe the boundaries of the property, and then someone saying, no, that's actually my property. So you have, it becomes very contentious.
Well, you said it comes from the fact that they used to use older equipment with surveying. Did they ever try and go out? Did they say it's a surveyor's fault? He should have to fix it?
Well, it's, of course, there's usually a statute of limitations issue on that.
Okay.
But I mean, theoretically, yes, you could. If a surveyor drew a line incorrectly, then you could try to have some recourse against the surveyor. And at one point in time, I researched that issue for a different case, and I forget exactly what the rule is. I know a surveyor is not a guarantor of his work, so you have to establish a negligence cause of action. But yes, it is a professional liability issue for the surveyors. And that can arise. That's a great example is, let's say I want to construct a fence on my property, a boundary line fence, and I want to have a privacy fence. So I'm not, maybe I have some neighbors I don't particularly like or something. And I get the property surveyed, and then I construct the fence, and what the survey indicates is 1 foot on my side of that common boundary. And then the adjoining property owner comes back and says, well, wait a minute, my survey says your fence is on my property. Well, there's a question where the surveyor may have some potential liability if indeed it's established that the common boundary is what the adjoining property owner says it is, as opposed to what your surveyor said it was.
Well, yeah, I think that's a big hassle. If you've built a fence And
Well,
there's a foot difference.
they're gonna want it removed. Yes, that would be. And if you have two neighbors that already aren't getting along very well, and then that issue arises, then it can certainly become a very contentious issue.
Time and expense, yes.
And it looks like we're almost out of time for today's show. This has been Legal Bytes, and we've covered sort of a wide array of topics. We started talking about partition actions, and that led us into a discussion of how important it is for folks to put their plans in writing and how that can avoid conflict in the future. And we discussed briefly some of the issues of marriage and how that affects property rights. And then we also talked about some boundary line issues. We're almost out of time. Thank you for joining us. We'll see you next week on our weekly Legal Bytes.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
Your marriage is over. You've been abandoned, betrayed. You're angry, shattered, and heartbroken. Don't go it alone. When you are facing divorce, you need an experienced advocate to help protect your rights in future. And you need it from a man with